Thank you all for joining us today. I'm Pam Metzger. I'm the director of the Deason Criminal Justice Reform Center at the SMU Dedman School of Law, and I'm so pleased to have you join us today for the fourth in a series of 5 conversations about criminal justice reform that we're holding as part of the SMU Law Review's 2021 symposium. That symposium issue features the practitioners and professors who are part of these criminal justice reform conversations. And in lieu of a traditional symposium format, we've invited pairs of professors and practitioners who are writing on similar topics to join us for a conversation about criminal legal reform. Today's conversation is about the role of prosecutors in criminal legal reform. And I'm so pleased today to be able to introduce our 3 guests. Professor Kay Levine, who is a professor of criminal law and procedure at Emory University School of Law. She writes on issues such as how prosecutors make their decisions and is currently working on a book called The Inside World of Prosecution, which she's working on with Professor Ron Wright of Wake Forest University. We also have with us today 2 members of the organization Fair and Just Prosecution, which is a network of prosecutors who are really committed to promoting a criminal legal system that's grounded in fairness, equality, compassion, and fiscal responsibility. We have with us today Miriam Krinsky, who's the Executive Director of Fair and Just Prosecution. Her prior experience includes acting as the Executive Director of the Los Angeles County Citizens Commission on Jail Violence, and she served as a special advisor to the sheriff in implementing reform there. In addition, Liz Komar, who's the Director of Director of Strategic Initiatives at the Fair and Just Prosecution. And she previously was an assistant district attorney in Brooklyn, New York, where she worked in the trial unit and at the Red Hook Community Justice Center, which is the country's really first multi-jurisdictional community court. She's also worked in areas of immigration rights and served in the Civil Rights Committee and the New York City Bar Association. So I'm so pleased to have our guests join us. As I said, these are conversations that are designed to explore issues of criminal legal reform. Each of the folks who are speaking with us here today has written a piece for the SMU Law Review, which is a symposium issue that talks about criminal legal reform and that shares insights where the academy meets practice. And so I'm going to begin by asking Miriam, if she could, to give us an overview of the progressive prosecutor movement and its practice. Miriam, I think you're on mute. There you go.
Thanks so much, Pam. And I want to thank you and your colleagues at SMU for setting the stage for this discussion, and also really thank those of you who are joining us on Zoom in what I hope will be more of a conversation than simply us in virtual space talking at you. So where I see this movement, so to speak, is really enlightened by my experiences as a prosecutor that go back now to the 80s and 90s. I saw during those years as a federal prosecutor a system that was in the early days of the ramp up of tough on crime, mandatory minimums, so much that set the stage for the problems that we see all around us today. I saw during my years younger and younger individuals coming into the criminal legal system for longer periods of time, very much of an autopilot presumption that we could punish our way out of substance use, out of mental health challenges, out of poverty, out of individuals and communities that were struggling. And while there were, at least by some, well-intentioned efforts to address the needs of the community, what we really saw was the early days of what has played out in terms of mass incarceration and a place where our nation sits with the dubious distinction of an incarceration rate that is second to none in the world. We ended up finding ourselves decimating communities, individuals, largely communities of color, bringing generations of young people, often young Black men, into our criminal legal system. And sadly, while we were spending huge amounts of money, we just weren't making our communities any safer. We were creating intergenerational cycles, and it was a waste of lives. It was a waste of money. And so scrolling forward then, Pam, to your question, today where we find ourselves is in that very unusual place that I thought we would never see, which is for the first time, we have communities demanding something different and electing individuals into offices as prosecutors. Let me just use the term DAs, even though that label isn't the one that applies in all parts of the country. But we see communities embracing candidates for DAs and electing DAs that want something different. In many parts of the country, these individuals who have been elected are breaking a glass ceiling through their election. Many of them are first. A number of them have challenged and beaten incumbents. Some of them never spent a day as a prosecutor before assuming that office. And while many do refer to them as you have, Pam, as the progressive prosecutor movement, I don't think that this necessarily is progressive or alone, or that it is only of a certain party mentality. It is bipartisan. We are seeing these individuals being elected in rural and urban areas from coast to coast and everywhere in between. They are not, as I mentioned, of a singular party, and they are bringing a new way of thinking. They are demanding that we shrink the size of the criminal legal system, that we rethink transparency and accountability. They are bold. Most of them have never run a large government institution, such as a DA's office. And many of them are facing, as I'm sure we'll have a chance to talk about later, tremendous pushback as they are assuming these offices. So our organization, Fair and Just Prosecution, tries to help them in this tremendous endeavor that they're undertaking to make that job a little less lonely, because it often is a very lonely one, to show them that there are others around the country who share that starting point, who share the mindset that they're bringing, and also to provide them with an ability to succeed in what they're doing. And we feel privileged to have a chance to look at them, to work with them, and as I know we'll be talking about, to see the changes that they're bringing about.
Thank you so much for that. That's a really important place to bring us to. Can you just help us understand how Fair and Just intersects with that trend? Tell us a little bit about your work and the work you and Liz do together.
Yes, absolutely. So FJP, Fair and Just Prosecution, tries to create somewhat of a community among these new leaders, a place where they can come together, where they can talk about the common challenges that they're facing, as well as share with each other the innovations that they're putting in practice, so that they can learn from each other, as well as have an opportunity to learn from experts around the country. We try to bring them to places, not simply in our own country, but also around the world, because I don't think that our nation should profess to know all that there is to know about changing our criminal legal system. There are many parts of the world that are doing things quite a bit better than we've been doing things in our country. So we provide them opportunities for learning, sharing of the best thinking among experts around the nation. And we look to bring their voices together to recognize that there are times when multiple voices can make a strong statement, especially when it comes from a law enforcement or prosecution background, in regard to changes in hot issues that are percolating around the country. We've filed multiple amicus or friends of court briefs around the nation that bring their voices together in rallying around issues of the day, everything from the need to rethink and eliminate the death penalty, to getting immigration enforcement out of the hands of local police, where we're simply eroding bonds of trust, to rethinking how we attend to the needs and challenges of juveniles and young people in the system. And we look to enable them to understand and embrace some of the best policies and best models in the country, whether it's police accountability and reform, to conviction integrity review or reviewing past decades-long sentences. What does it look like to think about that North Star, what they should strive to achieve as it comes to both shrinking the system and enhancing accountability and transparency?
Thank you for that. I want to turn to Kay and ask Kay, you've been conducting empirical research into the work of prosecutors for years and taking those accounts from prosecutors themselves, right, through surveys and other instruments. What lessons have you learned about the role that prosecutors can and do play in changing the way justice systems operate?
So thanks, Pam. And also I want to say thanks for the invitation from the editors of SMU, and also that spend more time with Miriam. I always enjoy getting a chance to see her and getting a chance to meet Liz for the first time. You guys are doing amazing. So honored to be part of a conversation. We get to build on each other. This is not going to be a conversation where sparks fly. I think on so many we agree on so much. And from the academic perspective, we have been championing a new role for prosecutors for so long now. And it's really exciting to see so much that's happening on the ground, being supported by organizations like FJP and getting seated in different parts across the country. So the question, what is the role for prosecutors here? And I really want to focus on two things: judgment and opportunity, because without those two things together, prosecutors wouldn't be able to accomplish much at all. So we start with the observation that prosecutors have the opportunity to have control over or a significant hand in a lot of decisions in the case management in the management of their individual caseloads. They decide whether to file charges, what charges to file, and what combination, usually with an eye toward results. They ask, what do I want to happen to this defendant? And then what is my strategy to file a set of charges to get me there? Whether to be generous or stingy in their interpretation of their disclosure obligations, whether to seek bail and how much, or alternatively, whether to agree to pretrial release, how much to involve victims in decision-making, what sort of plea deal to offer if they're going to offer one at all, whether to pull it off the table at some point, how plea deals intersect with pretrial motions by the defense, and so forth. All of these opportunities then intersect with the prosecutor's individual exercise of judgment and the judgment that he or she has gotten the leadership of the office. Now, it's important to remember in the United States, we don't have compulsory prosecution in our system, or if it exists in only very predefined pockets. Compulsory prosecution schemes exist elsewhere in the world, but here we believe that prosecutors ought to this kind of judgment in their individual cases and in cases at all. In fact, nobody prosecutors to be stripped of this kind of judgment or the opportunities to exercise judgment at lots of different points in the case. Allowing prosecutors to have judgment means that legislators can draft laws that are extremely broad and have no accountability for doing that, because prosecutors regularly save them from the full reach of these laws. Prosecutors like having lots of tools and choices that these laws provide for them. And it's this kind of judgment, the use of particular tools in particular circumstances, that has gotten some prosecutors in trouble in the past, that has led to the kind of systemic injustice that created a pattern of mass incarceration that sets us apart from just about every other democracy in the world. I also think that opportunity and judgment that offers hope for what's to come. And that is that it's this combination of opportunity and judgment that gives prosecutors a primary place in and implementing justice reforms across the board. So making life in the criminal courts, but also for communities across the country. What's exciting here is that prosecutors don't have to wait for legislators or for courts to handle a ripe controversy. Prosecutors, because they have so many opportunities to exercise, get to do things. They get to reject the tools that their predecessors relied on in order to create a different pattern than this constantly ratcheting up spiral of charges and incarceration and decimation of communities. They get to create new tools for their employees to use based on new policies that form the platform of their electoral campaigns and now govern their offices. So we see this with prosecutors declaring that they're line attorneys We'll have a radically different approach to pretrial release than existed in the previous office. A radically different approach to filing low-level theft crimes or low-level drug crimes. And sometimes even a significantly different approach to handling crimes of violence. And those changes can all be accomplished without legislative action, simply because the prosecutor is making a choice to take advantage of an opportunity that his or her election has provided. But I also want to make the point that the prosecutor role in justice reform is not limited to case management. We have to think about prosecutors in all of their other roles. Prosecutors interface with community groups. They build relationships with the bench and the bar. They lobby the legislature for laws that they want to see. And in all of these instances, all of these opportunities that prosecutors have to insert themselves and insert new ideas, they can choose to throw their weight behind issues of substantive. And what's so exciting about the point we're in right now is that increasingly we see in big cities and in some rural areas saying, I'm going to find substantive justice first. And because the constituents want, seems like the right thing. So the prosecutorial role in justice reform is multifaceted, and it is complex, and it's exciting. So I'm happy to have the chance to talk about this for the next hour.
Well, thanks for that. Let me follow up, because you have these progressive prosecutors being elected. You're talking about the role that individual prosecutors play. How realistic is it to expect that a progressive elected DA changes the culture of prosecution in the rank and the file? I mean, on the one hand, you've got, the Krasner model, where we saw a massive termination, right, of some of the old guard and an influx of new assistants. And then you have other models. Dallas is a pretty good example, where the DA really has made an effort, with the exception of some of the top leadership, to say, let's work together and see if we can't all be on the same page. How does the leadership change the rank and file?
So I think that is a great question. And my main writing partner, Ron Wright, is probably in some ways better suited to comment on this than I am, but I'll take a stab and then invite Ron to join in if he feels like I missed something. I think it's very challenging, actually, because in office, well, we have to acknowledge that most are not large. Most offices in the United States are about 10 people, 7 people. So every time research focuses just on the very large urban offices, we're missing a very significant chunk of what it means to practice law as a prosecutor in the United States. But be that as it may, inside the office, we have the elected, who has the campaign platform, and we have the line attorneys who are doing the work. And in the middle, we have mid-level staff. And many of those mid-level staffers have been with the office for quite a long time. They think of themselves as career prosecutors. And so many of those mid-level staffers joined on to the job of being a prosecutor under a different vision, under the old conventional vision that Miriam was describing in her opening remarks. So the challenge, I believe, and I think that Ron and I have found from our interviews with people, is that when the elected comes in with a new vision, he or she might be able to hire a whole set of line attorneys who subscribe to that new vision, but the mid-level staffers, the people who hold the rank of, let's say, deputy chief, may not subscribe to that vision and may look for ways to evade the vision. So there, in sociology, we say the techniques of institutional evasion are very common in large bureaucracies. There are lots of ways to duck and cover to avoid accomplishing what bosses or the rules tell you you're supposed to accomplish, and yet you have ways to cover those tracks. So I think this has continued to be a problem, actually, in the Philadelphia DA's office. There was a mass firing when he came on. I think he fired 30 to 35 people, but it is my understanding that the techniques of evasion at the mid-level remain problematic. And I think, there's only so much of an office of hundreds of lawyers that you could purge at once. It's hard to replace the kind of experience that those mid-level staffers bring. So it's also my understanding one of the offices in the St. Louis area has had a turnover in personnel since the reform prosecutor took over, because none of these subscribe to the new vision. So, but it takes a long time kind of experience, the trial lawyer experience, and the judgment of valuing the evidence that those mid-level staffers represent. So I think there's a tension for the newly elected terms wanting to retain some of the and yet infuse a new kind of that will keep the office focused on the new mission. But I believe it is a constant challenge.
Well, thank you for that. Bearing that in mind, Miriam, what are we seeing these prosecutors, and I think you're right to challenge the terminology of progressive, right? Because it is happening across the political spectrum. What would you say that these change-minded prosecutors are accomplishing? I mean, there's policy and then there's practice. What are we seeing happen here?
So I think we're seeing, and I'm going to invite my colleague Liz to maybe amplify some of these details. I think we're seeing change fundamentally in two areas, and they very much replicate the two pillars that are part of the FJP and other partners' 21 principles of 21st century prosecution. We are seeing change when it relates to rethinking that front door that Kay talked about earlier, and when and if the criminal legal system needs to engage at all, and shrinking the system, reducing its footprint, changes around who needs to come in, what should be criminalized at all, where should the scarce resources of a prosecutor's office and sort of that heavy hammer of prosecution be exercised. When should individuals and young people in particular be filed on as adults, and when can we keep them in a more age-appropriate juvenile system? So that starting point of the breadth and the reach of the criminal legal system is being rethought, just as they're rethinking a whole host of areas around transparency and accountability and fairness. How do we think about taking a look and not just perpetuating a just system moving forward, but revisiting past cases through conviction review, through sentencing second chances, or in other ways, ensuring that there is that all-important accountability and transparency that comes along with rebuilding faith and trust in the criminal legal system. And let me maybe, if I can, Pam, turn it over to Liz and let her give some more details in that regard.
Thank you, Miriam. Liz, take it away.
Yeah, thank you so much. And as a starting place, just to add to that, I think also what reform prosecutors are doing is redefining the goals of prosecution and redefining the roles of a prosecutor in many ways. And so that means moving beyond these traditional prosecutorial metrics of success, which are recidivism and conviction rates, and saying that ultimately our goals are things like improving community well-being, reducing incarceration, improving equity and public safety as a part of all of that, that ultimately our communities aren't safe if they're not also fair. And so I think that framing is important for when we talk about the reforms that have commonly been implemented by reform prosecutors, because they vary. Not every single reform prosecutor has implemented all of those, but they're all grounded in those same values. So kind of that first bucket of reforms that Miriam mentioned, which is reducing the size of the system and reducing incarceration through bail reform, declination, decriminalization, diversion, and refocusing resources on where they matter most. A quintessential example of that is the marijuana decriminalization that we've seen in so many communities. 1 in 3 Americans will soon live in areas where cannabis has been decriminalized. And then I think some of the prosecutors that we work with are also moving beyond that low-hanging fruit of decriminalization. For instance, Marilyn Mosby has a diversion program that works with first-time nonviolent felony drug offenses, which is incredibly important since we know that there's an enormous amount of overlap between people who use drugs and sell drugs, and that ultimately those slightly more serious drug cases are major drivers of incarceration. And we've also seen more public health thinking on the drug front, such as in Chittenden County, Vermont, where the state's attorney, Sarah George, and her police chief announced that they would no longer arrest or prosecute individuals for possessing buprenorphine, which is incredibly important from an overdose prevention standpoint. And I think that's a really good illustration of how prosecutors are starting with different set of values and metrics of success in implementing these programs, because the starting value there is saving lives instead of rotely enforcing the law. And so, beyond that, I think some good examples of common reforms that we're seeing are also just implementing policies where prosecutors are declining to prosecute a wide array of very low-level offenses that are closely associated with poverty, serious mental illness, and the racial disparities that churn through the justice system. So a good example of that would be Rachel Rollins's memo in Suffolk County, Boston, in which she identified 15 charges that are best addressed through a diversion or declination entirely, including trespassing, shoplifting, disorderly conduct. And we've seen that approach now increasingly replicated by other DAs. And I think it's important to also note that recent research has also shown the efficacy of declining to prosecute some of those low-level offenses for actually ultimately reducing recidivism. And so beyond that, I think we can see prosecutors also beginning to engage with some more serious offenses, particularly in the juvenile landscape, moving beyond juvenile life without parole sentences, committing to not seeking the death penalty, and embracing across the board more evidence-based approaches to justice, which often means thinking about lesser sentences. So that's kind of that first bucket of decreasing incarceration. And then I think there's an important second bucket of improving transparency and accountability within their offices in both a forward-looking way and a backward-looking way. And so that includes implementing systems to collect data that reflect some of those important changes in metrics that I mentioned, which is a way of showing to the community where racial disparities are, what's succeeding, what isn't succeeding. It also includes internal policies around improving discovery, implementing Brady lists so that the office isn't relying on problematic police witnesses, internal culture change work around, say, training, and then also, importantly, looking at conviction integrity and excessive sentences through conviction integrity units and sentencing review units. And then, more broadly, I think the third bucket is just prosecutors using their bully pulpit for systemic change, because for so long, the prosecutor lobby has mostly existed to disrupt opportunities for reform, just knee-jerk opposition to almost all criminal justice reform in legislative contexts. And now we're seeing prosecutors engage in a different way, both advocating for change and transformation and also serving as conveners for change.
Thanks, Liz, for that. Let me just let our audience know we will be getting to a Q&A portion of this program around, well, depending on your time zone, 4 o'clock, 3 o'clock, 2 o'clock. So please feel free to put your Q&A in the Q&A box. I also want to just highlight here that periodically you'll see resources appear in the chat box. FJP's 21 Principles for 21st Century Prosecution are now there. The memo, the Rachel Rollins memo that Liz just referred to, will appear there. So you might want to take a look there if you want to track some of those resources down. Kay, I want to pick up on this this idea of prosecutors, on the one hand, having enormous power and being able to use a bully pulpit, being able to kind of speak to legislators, and at the same time, the reality that what prosecutors do takes place in the context of a much larger criminal legal system, where battles about change, reform, abolition are playing out. I'm, very much conscious these days in my own mind of the idea of displacement, right? That police can simply choose one to arrest anyway on charges that prosecutors aren't going to file, or they can displace those arrests onto same people, different offenses, right? How do prosecutor reforms, prosecutor changes in practice track what else is happening in the criminal legal system, and how do they mesh or not mesh with the other system actors?
So I think that's a great question. I think, it's more like, how do they intersect? I don't know so much that they track, in the sense that tracking suggests there's either a cause and effect relationship or that it's kind of sequential in time. But I think that prosecutors are certainly aware of changes that are happening on the policing front. And sometimes the way police officers are behaving motivates prosecutors to behave differently than they otherwise would have. So, because police officers they are not just making arrests and putting cases in the justice system as part of a larger legal system push. Police officers are also men and women doing their job, and they're in a union, and they're looking for better pay and better benefits. I recall in one of the conversations that we had for some of the interviews that Ron and I did in an earlier project, prosecutors told us about something called blue flu, which was police officers deciding they were going to make a whole lot fewer traffic arrests. They knew that traffic money drives the coffers of their local jurisdictions, and police officers were in a fight with the county agency in charge of their funding, and they were not getting the raise they thought they deserved. So they said, we're just not going to make any traffic arrests, or we're going to dramatically reduce the number of traffic arrests that we make, which gives prosecutors far fewer cases to file. But it is because this is police officers not out of compassion for the drivers, but rather out of a sense that their union was not being treated fairly in negotiations with the county board of supervisors. So I think it is also the case that when we think about what police officers do, arrest is simply one thing that they do. And actually, criminal justice is only one thing that police officers do. It's a much, much bigger job than that. Much of what police officers do is community intervention. They get a call about somebody's grandmother might have died. There's an odd smell coming from the house. There's all kinds of other things. So when we're in the legal system aspect, we tend to focus on police officers as the entry point funnel for cases coming into the legal system. But police officers interact with citizens and residents of the community in so many different ways. And as do prosecutors. Prosecutors, I think, do their jobs better when they recognize that much larger funnel and don't simply divide in their mind everybody in the community is either a victim or a defendant, or a potential victim or a potential defendant, but rather we're all in this together in terms of wanting to reduce victimization rates across the board, to make communities safer and happier, like to increase the wellness and the welfare of the community generally. And we clearly have not gotten there, as Miriam said in her opening remarks, through our addiction to arrest and our addiction to punishment. That has decreased welfare across the board rather than increased. So I think when prosecutors recently, at least in the last decade, have started to take really seriously their role in making some changes, it's because they recognize that these levers fit together in ways that are not neat. Some things are orthogonal to other things, sometimes are contradictory. If we look to a couple of examples of movements for reform that haven't originated in the prosecutor's office, and look to see where are prosecutors going with this. The first thing I thought of was community bail funds. That is, large large organizations of people in a community have decided we're going to pool our money to help people make bail when they can't make it on their own, or their families can't do it on their own. I would like to say that prosecutors were behind that effort, but I don't think they were. I think that largely they were annoyed and frustrated by the efforts of the community bail funds. And now we're several years into that, and many prosecutors have embraced bail reform for their own reasons, as they've gotten more open-minded about the relationship between pretrial release, pretrial detention, and community safety. But I think initially they were opposed to the idea of community bail funds. From the other side, we can look at police who have created, in a number of communities across the United States, initiatives for deflection. That is to decide, when we encounter somebody on the streets who has allegedly engaged in some sort of low-level behavior, usually it's crimes associated with poverty or homelessness or addiction or mental illness, as Liz was describing, officers make the choice not to arrest, not to channel this person into the criminal justice system at all, but rather to call a caseworker and initiate services for this person rather than a legal system intervention. And prosecutors, in my view, have been largely watching this from the sidelines. There are a few definitely counterexamples, and Lead in Seattle, led by Dan Satterberg, is one very prominent one where prosecutor's office was at the front lines of this effort. But in a lot of other places, this is police officers working with community health agencies and rehab facilities to say what we've been doing is not working. And we haven't seen much prosecutor involvement yet. And so for prosecutors who are watching this call, I want to encourage them to get involved in this, because this is an area where reform being led by other community groups and other institutions is generally heading in the right direction, has very good results in terms of recidivism and community reaction and user reaction to being treated this way. So prosecutors, instead of being on the sidelines of this, instead of resting on pre-existing diversion programs, which exist in their own offices and are funded, channeling the money into their offices, I'd like to see prosecutors say, hey, that's a really good idea that originated outside of us. We're going to embrace it, we're going to champion it, and we're going to help raise money to get this this core of an idea real off the ground and spread it more widely and more in a more textured way across more programs to help more people.
Well, thank you for that, Kay. And I'll note there that, in fact, Lead was actually launched by a public defender, right? There's a really great example of a place where a prosecutor, right? And Dan is, of course, is an FJP veteran, and he said, that's a great idea. I don't care where it comes from, right? You all wrote articles, essays for the SMU Law Review Symposium, and you chose to really speak to each other. And you wrote about the diversion movement. And for those who aren't familiar with it, diversion is when prosecutors choose, after an arrest comes to them, to sort of say, we're not going to pursue this case if the defendant does X, Y, and Z. And the diversion is usually programmatic. It's sometimes very costly, depending on where you live. It may be prohibitively costly. And you chose to write, and again, to speak to each other about a diversion movement and its sort of tricky intersection with the interests and rights of victims. And of course, Kay, you also referenced the fact that really we don't live in a world where there are victims and defendants. Most defendants are themselves victims, right? Particularly if we think about a trauma-informed way of understanding criminal legal services. So I'm going to ask you, Kay, if you can just briefly unpack what we mean by a diversion movement. And then I'm hoping that Miriam can follow up and talk a little bit about the challenge in terms of conceptualizing a world in which we don't just have victims and defendants as two different groups. So.
Sure. So when we talk about the diversion movement, what we're really referencing is an initiative that started in earnest in the mid-90s, but definitely gathered steam, sort of parallel to the growth of accountability courts, which are generally controlled by judges. But diversion programs exist inside prosecutors' offices, and they are motivated by a combination of fiscal responsibility, compassion for the offender population, and a sense that we need to have more proportionality in how we think about criminal justice outcomes. So rather than the full court press, we start a case by filing it, and we are going all the way through to conviction and imposition of judgment, fines, probation, incarceration, et cetera. Diversion programs are motivated by the idea that many people do not need the full court press of prosecution, but rather from the moment a case has been filed, they are amenable to some kind of services, some sort of lesser treatment. They don't need the whole thing. But if they were simply to go to some set of classes or do some community service, participate in drug testing if it's a drug case, attend some sort of skills-based classes. The goal of diversion is largely about rehabilitation. That if we divert people out of the system instead of assembly line processing them towards conviction and judgment and punishment, that we will be spending our money wisely, saving their lives, treating them with compassion and dignity, and saving our resources for the really serious cases in the system that warrant it. So what Miriam and Liz and I chose to focus on in our essays is, well, with these programs, which have proliferated across the country, and many offices have multiple diversion programs going at this point, one for shoplifting, one for sex workers, one for substance abusers, and so forth. What do we do in cases that involve victims? And the victims' rights movement has had some political success over the same period that the diversion movement has had some success inside prosecutors' offices. The victims' rights movement is claiming that victims have been ignored, victims have been maltreated, victims should have a greater say in what happens. And much of the rhetoric of the victims movement is that offenders are being let off the hook and there's nothing victims can do about it. So the topic that Miriam and Liz and I wanted to explore in our essays is, first of all, is that really true? And secondly, given the choice between fidelity to compassion and fiscal responsibility and proportionality on the one hand, and listening to a victim who has a particular viewpoint based on his or her experience surviving this particular crime, what ought the prosecutor to do when faced with a tension between this set of ideals that animates diversion and a victim who is insisting on his or her statutory or now constitutional rights to be involved?
So Miriam, Kate's laid out a lot there for us to talk about, but I want to start by asking this question: what do we mean when we talk about victims, and are we getting it right in the context of the criminal legal system?
Yeah, no, thanks for that, Pam, because I think that really is a key question, and all too often there's this presumption around what do we really mean by victims or survivors, who speaks for them, and a false assumption that there is a monolithic point of view represented by individuals who have been impacted by the misconduct of others. And I think when we look at polling that's been done, what we see is that the views of those who are survivors of crime are much more nuanced than people often assume. And in fact, and I'm going to let Liz expand upon this in a minute, in fact, often those who have seized the megaphone are only a very small subset of individuals, and often they are white survivors who are at times more affluent or have greater reins of power, and by virtue of that, they have defined a dialogue that really is not the narrative of most survivors of a crime, many of whom can float between being victimized by others or being on the other side of the justice system. And if we look at some of those vulnerable communities and communities of color, what they want is often not that presumptive, quote unquote, throw the book at the individual type of response. What they want is often not a punitive or even a criminal legal system driven response. They want to be heard. They want to be respected. They want to be made in some ways whole, which doesn't often, and in fact, rarely happens through the criminal legal system. In fact, very often we re-traumatize individuals who have been survivors of crime when we force them through a criminal legal response. So let me maybe turn it over to Liz to kind of expand upon that. But I think that we are not going to get this right unless and until we widen our lens and look at a broader categorization and a broader sense of who and what, who are and what do survivors of crime want, and think long and hard, and I saw this in one of the questions and hope we'll get back to it, think long and hard about whether the criminal legal system is even the right starting point, because diversion programs are better, but they are not best. And best is often the criminal legal system getting out of the way and not being the starting point and not presuming that the way we the way we treat the underlying problems that can often lead to criminal misbehavior, the way we address individuals struggling with mental illness, the way we attend to those who have been traumatized or who are dealing with poverty, who often by virtue of that engage in conduct that is at odds with the law, that those responses are often best doled out not by judges, not by people with a legal degree, not by our criminal legal system, but by other social networks that can more cheaply, more effectively, and doing less harm respond to the problem. And we are better off having a criminal legal system that does no harm, that deflects people away from it, that has exit ramps at the earliest opportunity, rather than engaging and putting people through sort of that funnel and that never-ending, downward gravitational pull that only makes things worse rather than making them better.
And Liz, I'm going to hand it off to you, but folks on this call, folks who are watching, might want to take a look at a recent study that was released by Dr. Anna Harvey and some others on the work that's being done in Rachel Rollins's office, again, talking about Suffolk County, Massachusetts, that shows that non-involvement with the criminal legal system is the best thing you can do for people. Liz?
Sure. Thank you so much. Yeah, and just to expand on what Miriam said, Miriam hinted at really the impact of carceral feminism on how we define the prototypical survivor of crime. That the victim rights movement of the 1970s centered whiteness, and it lifted up the young white female rape survivor as the prototypical victim. And the enormous cost of that has been that it's erased the experiences of the people who actually most disproportionately experience victimization, which is communities of color. And I think we see profound consequences of that in that we still don't meet the needs of the vast majority of survivors of crime, and the majority of violent crimes still go unreported. And so, the reality of the demographics of those who are victimized is that people of color are 15% more likely to be victims of crime, and nearly 1/3 more likely to be victims of violent crime than white people. The majority of homicide and robbery victims in the United States are Black men and children under the age of 24. And that an alarming 22% of Black women in the US have experienced rape, 22% will experience intimate partner violence in their lifetime, and they're killed at a much higher rate than any other group of women. And those numbers are even higher for Black, trans, and non-binary individuals. And so those statistics suggest many things beyond the scope of our paper about the ways in which systemic oppression propels victimization. But for our purposes, we try to engage with how mass incarceration can ultimately increase victimization by perpetuating cycles of harm in communities. And in particular, how we ultimately criminalize many survivors of crime. And in part, that's because, as Miriam said, nearly all those who engage in violence have also survived it. And this is clearest in the context of urban gun violence, where cycles of fear, trauma, and retaliatory violence, and also lack of opportunity and systematic marginalization, which undercut desistance factors, result in escalating violence. And so a recent study, I'd say, that really strongly illustrates this was recently conducted by the Center for Court Innovation, in which they interviewed a number of young men who carry guns about why they do so. And ultimately, it was mostly out of fear of the police, fear they weren't offered protection. And I think really the pioneers of leaders of restorative justice, Fania Davis, Sujatha Baliga, and Danielle Sered, expand on this point so eloquently in everything they write. And more broadly, we criminalize trauma, which is an enormous reason that we have what is referred to in scholarship as the victim offender overlap, which is a terrible term. And it's clear that we criminalize trauma by the rates of trauma among people that we incarcerate, which is that incarcerated women report a lifetime prevalence of post-traumatic stress disorder at 53%, 5 times that of the general population. And in particular, if you look at girls in the youth justice system, research in some states shows that 80 to 90% of girls in the youth justice system report prior sexual abuse. And a lot of that is because we criminalize trauma responses. Particularly again in young girls of color, we have a well-documented sexual abuse to incarceration pipeline, and that's because we criminalize things like running away from home as status offenses. We criminalize anger in schools by placing police officers there, and all too often in a number of recent high-profile cases, we've seen youth criminalized for defending themselves against abusers, and then of course we criminalize the sequelae of trauma when we criminalize substance use, serious mental illness, and even poverty. And so that, results in a lot of this difficulty that really in distinguishing between the folks that we want to call victims and the folks that we want to treat very differently, that ultimately it's often the same people who need more holistic solutions.
I'm reminded listening to you talk, Liz, of what might be the ultimate example of of this, which was in what is probably the farthest thing from the kind of prosecutor we're talking about, a practice under the former district attorney in New Orleans of incarcerating victims of domestic violence as material witnesses in order to force them to testify, which is probably the most prominent example I can think of a system that is aggressively re-traumatizing victims in the name of vindicating interests that they may not even have. And of course, predominantly in African-American communities, there's a real fear about calling the police when you've been victimized because of over-policing. But I'll leave that there. Let me ask, there are various ways to think about respecting the tragedy and the trauma that people have experienced and trying to provide them with services. And as Miriam says, there's a lot to be unpacked about whether the criminal legal system is really the right place to do it, whether forcing people into programs, into treatment, into services is the right way to go, particularly when these are people who have experienced, in the way Liz describes, right, their own experiences of a trauma, of a loss of control, of a loss of autonomy. There's also, I think, a lot of confusion about the ways and the moments in which prosecutors can exercise that power versus the way in which police can exercise it, right? Can we just for a minute double back on some vocabulary? And I'm thinking here about the terms deflect, divert, decline. And if we can kind of unpack what those mean, because we do have some students who are joining us today, make sure we're really on the same page here. Kay, you want to take that one?
Sure, I would be happy to. So I think we start with the binary of full prosecution or decline. A police officer gives you a case and you start with two choices. Am I going to initiate charges with the goal of moving it all the way through the system in order to get conviction and imposition of judgment? Or am I going to decline to file, in which case nothing happens, the person is released from custody, and simply goes on his or her way. There's a record of an arrest, perhaps, but nothing else happens. So we begin with that binary, file charges or decline. Then we add the third option, which emerged in the 80s and 90s and the early 2000s, which is divert. Diversion programs generally worked on the model of you file the case first, and then you offer somebody a route out, a contract with terms and conditions that they have to obey. And if they comply, over the course of 18 months or 3 years, however long the program was, at the end of the compliance term, if they haven't violated anything, then the case gets dismissed. Some of the diversion programs require the defendant to plead guilty first, then comply with all the conditions in terms of in their contract, in which case compliance meant at the end of the contract term, the case comes back to court, you get to withdraw your guilty plea, and then the case gets dismissed. But here's the kicker: if you don't comply, and if the prosecutor decides to file a violation against you, then your guilty plea is already in place. We put it back on the criminal court calendar and we just go right to sentencing. So prosecutors liked that model because it made it very easy for them when people washed out of the program. But many people in the community and many people on the defense side of the aisle thought that it was extremely unfair. It was an egregious due process violation to require somebody to plead guilty before they could take advantage of services. So now the programs that Miriam and Liz and I are talking about fall under the heading of deflection, which is before the filing point on the timeline. So before, it used to be it was file, divert, or file and full prosecute now, but deflection is before the filing point, where we're saying police officers are going to make a choice when they intercept somebody on the street, not to even make an arrest, not to generate an arrest report, not to send that person into the legal system at all for prosecutors to then decide what to do with. Deflection means you're literally bouncing off the edge of the system before you ever get in it. And this means that your access to services does not hinge on your compliance with prosecutorial mandates or your willingness to plead guilty in order to get services. The officer on the front end is going to call a caseworker, and that caseworker is going to come, do a fairly quick assessment of what your needs are and be able to get you into treatment. And there's a range for the deflection programs that exist out there. There are a range of treatment models. Caseworkers many times are recovering addicts themselves, so they know how it feels to be manhandled in the system versus treated with more respect and dignity. The point of the deflection programs is that entry into services is voluntary. There is no threat of criminal justice sanction that hangs over your head. There's no threat of criminal justice sanction that will follow you around if you don't comply. You're saying, I'm choosing services. And however well you commit to services is however well you commit to services. If you wash out, you wash out. There's no criminal case that sort of forms the backstop. So what we have found so attractive about deflection is that once we've removed the hammer of criminal justice consequence, and we remove the stigma that flows from arrest itself. And these days, arrest gets you in a database. And once you're in a database, that database is accessible to future employers, the military, future landlords, all kinds of people have access to arrest databases. Very, very hard to scrub once you're in one of those databases. Deflection keeps you out of the database altogether. It actually gives you a fighting chance to get help from people who are motivated to provide it. The other thing about the deflection services is many times people can take advantage of them as many times as they need. Diversion sometimes is you get one shot at it. And once you've been diverted, if you come back into the system, diversion is off the table. But one thing that I find very appealing about deflection is it recognizes, particularly for substance abuse users, that relapse and recovery is a cycle. And so it doesn't make any sense to give people one shot at recovery and expect them to succeed. We have to meet them where they are. And that means multiple chances. If we really want them to succeed, and we should want them to succeed, we have to give them multiple chances.
In fact, the data show that people who enter into these kind of diversion programs that are tied to drug rehabilitation, right, and to substance abuse treatment, for those who survive those very rigid programs, they do great. For those who go in and fail, the outcomes are exponentially worse for precisely the reasons that I think you've described. Miriam, can you talk a little more about all of this, about the role of deflection and how prosecutors can play a part?
Well, I think, and Kay gave such a beautiful explanation of all of this. I think first and foremost, if we're talking about elected prosecutors, realize that they have a bully pulpit. They are elected leaders. They're prosecutors, but they're also politicians, frankly. And so they really have the ability to push as a policy choice the starting point that the criminal legal system has filled too much space. We need to reduce the space that it fills. It is not the be-all and the answer for individuals struggling with poverty, with substance use, with mental illness, with homelessness, with a host of other challenges where social networks and public health and mental health, if the criminal legal system gets out of the space, may be more likely to fill that space, because we have tried for too long to presume that we need a hammer over people's heads before we can get them to respond. I mean, you cannot punish somebody's way into attending to their health or mental health issues. You cannot punish your way into presuming that individuals who are struggling with substance use disorder can have their behavior changed. We need to start in a different place, and elected prosecutors have the ability to advocate for a different starting point. I think we also need to think long and hard about what you referenced earlier, Kay, which is the fact that the criminal justice system is often criminogenic. Or in other words, when we incarcerate people and then throw them back into the community, they are often, as the work that you referenced showed, as other studies have shown before it, they're often at greater likelihood of recidivating, of re-entering the system, and sometimes realize that that recidivism is driven by the fact that we mass supervise in addition to mass incarcerate. We will supervise people for years on end and keep that hammer of a criminal punitive response when they do what human behavior suggests is natural, when they relapse, when they can no longer, abide by these absurdly restrictive conditions that we place on them for years on end. So often we simply cycle them back through a system that has solved nothing, that has spent billions of dollars, that has damaged lives and communities to no end. So we have to really reevaluate, when is the criminal legal system the appropriate gateway, the appropriate doorway through which we should bring people? Or when is it better to just get out of their way, to turn them away? And frankly, even deflection, even law enforcement assisted diversion are models that my hope is a few years from now we'll be moving beyond, or namely, we'll be at a point where police are no longer the responders where someone is in a mental health crisis, or when they have overdosed, or when they're out on the street, engaging in nuisance type behavior, simply because they are struggling with housing issues. Law enforcement, people who have, a gun and a badge, are not the best trained or equipped individuals to deal with those struggles. So hopefully we'll find ourselves in a place where we're attending to those needs, not through law enforcement assisted diversion, but through public health, through social networks, through simply giving people a hand and treatment rather than a jail cell, or rather than a pathway from which we need to deflect them, because that has been the starting point. And the other thing that I would simply suggest that we think about is the need to be data driven. There is so much more we know about the consequences of what we have been doing for decades, the kinds of figures that Liz alluded to, the sorts of lessons that other countries have learned. We have put our heads in the sand for far too long in this nation and refused to allow ourselves to be data informed. And again, we have wasted lives, we have wasted money, we have damaged communities by starting where we start. And even if we don't have things fixed, simply disengaging, simply getting the criminal legal system out of the way will improve the status quo, even if we don't have every service, every support, every network out there. We can't wait to create those things. If we simply get out of the way, we will be better off in terms of people's lives and the state and well-being of our communities.
So all of those ideas, I think, ask system actors to do something that is profoundly difficult, which is to try and put themselves out of business, right? And we do that at every stage when we talk about downsizing the carceral state, right? It's asking police to make themselves less essential, to say we're not needed here. We're asking prosecutors to say, I'd like fewer people in my office. We're asking judges to say, no, we don't need so many seats on the bench. And that's a very difficult sell. And at the same time, you have political opposition. I think Tom Cotton recently said that we have an under-incarceration problem. I would encourage him to go visit a jail or a prison and see if he still agrees. But I think that it has to be the case, and we're seeing this play out now in a number of communities, San Francisco being one of them, where there is both an internal backlash, kind of the institution, the beast trying to survive, right? And an external backlash from people outside the system saying, recall them, right? Recall them. We don't want this in our system. What's going to happen here? I mean, is this a movement that has staying power? And how do prosecutors who are trying to make change survive those dual tensions? I will throw it open to anyone who can answer. I'm going to date myself, that $64,000 question. I think it has to be 64 million Bitcoin now, but.
Well, I'm happy to start. But your question about, are people going to put themselves out of business reminded me of a wonderful piece that was recently written by Aaron Collins about drug courts. And what Professor Collins writes is that drug courts have proliferated not because there's data about how effective they are, but because judges really like them because it makes them feel like judges again. She points to the whole trend for mandatory minimums and all kinds of structured sentencing that largely put judges out of business in terms of being professionals who got to exercise their judgment and put a stamp on an offender's future. And why judges like drug courts is because it makes them feel like judges again. So I think it's a brilliant insight. And if I find myself wondering if prosecutors are reconceptualizing their role, they might be out of business on one dimension, but they could be growing their community interactions in other dimensions. So if prosecutors thought more comprehensively, as I think many of our reform prosecutors are doing, if they thought more comprehensively about what it meant to be a community partner to help improve the wellness and welfare of the community in a number of different ways, not just by being case managers and handling whatever cases the police officers are funneling to them, they wouldn't be out of business. They would be I should say that the matrix of their business would shift, right? The particular composition of how they spent their days, and truthfully, the skills of the people they hired would be different. We're not just talking about people who are trial attorneys or case processors, whatever, but people who have a different set of skills and a different set of interests. And from what I can tell at Emory, where I am, and the students who are being hired by offices that are being led by reform DAs, there does seem to be a deeper conversation for hiring the line attorney level to hire people who have more than just a toolkit of trial advocacy skills. So I find that encouraging that, if we shifted the business of what it meant to be a prosecutor, we wouldn't have to put prosecutors out of business. And maybe we will downsize the offices some, which would not be a bad thing if those resources went into other institutions that are serving the public in these larger ways. That isn't a bad thing. We don't necessarily need more prosecutors. We need better prosecutors, more well-rounded prosecutors, and we need better funded social institutions to handle so much of the work that is generated through homelessness, poverty, mental illness, and so forth.
So that's the inside take, right? How do prosecutors think about their own organizations and about either downsizing or changing or both? What about the electoral politics here? Because we're seeing some really vicious electoral backlash, including recall efforts. Miriam?
Yeah, so, I don't know that I can tell you what the crystal ball holds, and it, it's hard to say with confidence, where will these recalls come out? How much staying power will there be in this movement? But I do have strong views. So let me give you my best guess without that crystal ball. It's not as though these last 4 years didn't have tremendous opposition to these leaders, to this movement, to the reform efforts that we were seeing percolate around the country. We had a president and an attorney general and federal leaders who were very much at odds with the growing number of elected prosecutors in local jurisdictions and states attorneys general who were trying to change paradigms. We had national policing groups, Fraternal Order of the Police and others, who were basically calling out, along with the Attorney General, what they deemed to be anarchist jurisdictions, what they labeled, social justice DAs, and doing everything within their power, including investment of police unions and others in races to try to unseat these individuals. And what we saw in the last election, despite all of that, was the numbers grew. None of the individuals who had assumed office in 2016 were unsuccessful in being reelected. And the numbers continue to grow. Communities want change. And so my view of it is that communities are smarter than all of this. Now, I saw the question asked about what about the next Willie Horton? Where will these pending recall efforts end up? I don't believe that they'll be successful, but I do worry that as crime has gone up in some areas by virtue of isolation and trauma and the removal of supports and services this last year, not because of these elected prosecutors, but because of the horrible situation in our nation and around the world with the pandemic that we've faced, I do worry that there will be an effort to attribute some of those things to this movement. But again, my view is the data will prove it wrong. And communities have seen the spread of the criminal legal system for decades. That is not what they want. They're making different choices. And I think that we are seeing a movement that is slowly becoming the new normal in the field of prosecution. How far it goes remains to be seen, but I think it has further to go over the coming years, and that, this clock is not turning back to where we were in the 80s and 90s in that so-called tough on crime era.
Well, thank you for that. So we are right at the end of our 75 minutes together. I want to thank y'all so much. This is just such a wonderful conversation, and be able to have it with these three amazing women who are at the front of this conversation. I also want to encourage everyone to join us next week for the last in our series of 5 criminal justice reform conversations. We'll be joined on that webinar by Professor Irene Joe, a former New Orleans public defender. I know we have a couple of those on the Zoom webinar right now. And by Chief Justice Bridget McCormick, who's the Chief Justice of the Michigan Supreme Court and also herself a former public defender. Thank you once again to our panelists and to the SM Law Review and the students of the Law Review for having the brilliant idea of putting together a symposium issue that would not just speak to law professors, but where law professors, practitioners, and advocates could speak to each other and to the broader community about these important issues that are facing not just the criminal legal community, but our country at large. Thank you all so much for joining us, and we will look forward to seeing you all next week. If you've missed the other conversations, you can catch them on our YouTube channel. Yes, we do have one of those. And for those of you who are looking for CLE credit, information about how to get your CLE credit is in the chat. If you don't get a chance to grab it before the webinar ends, please feel free to email us at the Deason Center, and we'll help you make arrangements to get those CLE credits. Thank you once again to our guests for joining us, and to all of you for participating. Be safe. Thank you.